Absolutely. And I'm using our courtroom standard background, which says do not record, even though we're recording. And so everybody knows that we are recording, even though, right, we're recording, even though it says do not record, we are recording it. And I want to welcome everybody here tonight to the finals. It is my great honor to be able to be here with you today. This is an honor that's normally given to our presiding judge for our county court, and unfortunately he's not available today. And I was asked and was offered this great honor of filling in for him, and I enthusiastically accepted. And so at this point, I'm going to ask if the bailiff would call the court to order.
Yes, Your Honor. Calling the court's attention, the Superior Court of the State of California, County of Alameda, Department A is now in session. Honorable Judge Kolakowski presiding. Your Honor, at this time, may I address the court as to the rules to maintain order for the courtroom?
Absolutely, yes.
Neither side is allowed to communicate with spectators for the duration of the trial. At this time, please silence all electronics, including cellular devices. Everyone's video must be off and microphones muted unless presenting. Finally, should Your Honor need a copy of the 2021-2022 Team Rulebook and Case Packet, I can provide the link in chat.
Thank you very much. And that was actually why I took a minute to stop earlier, is I wanted to make sure that I had my materials up and open on my screen. And so if I ever seem distracted for just a moment, it's because I'm reviewing the materials that are available for me as judge. Again, I'm Judge Victoria Kolakowski. I sit in Department 512 here in Alameda County, presiding over unlawful detainers, our eviction court. And I here expressing greetings from all of my colleagues here in Alameda County and from our presiding judge who cannot be with us today. And so with that introduction and with my great and with great honor on my part, I'm going to ask if the teams can identify themselves, starting with the prosecution, stating your name and the role for the evening.
Good evening, Your Honor. My name is Sydney Brown Wilson, and I will be representing the people of California in the pretrial motion. At this time, may our trial attorneys please introduce themselves?
Yes, they may.
Good evening, Your Honor. My name is Avery Forrestal, and I, along with my co-counsel, Jamie Collins.
Good evening, Your Honor.
And Celine Quanch.
Good evening, Your Honor.
We're representing the people in tonight's matter. At this time, may our witnesses please introduce themselves?
Yes, they may.
Good evening, Your Honor. My name is Elliot Beckner, but tonight I am Angel Russell.
Good evening, Your Honor. My name is Dylan Smiley, but tonight I am Deputy Sheriff Tony Garrett.
Good evening, Your Honor. My name is Gabriel Carney, but tonight I am Terry Edwards.
Good evening, Your Honor. My name is Belen Topete, but tonight I am Dr. Charlie Dunn. At this time, may the clerk please introduce himself?
Yes.
Good evening, Your Honor. My name is Gabriel Tarantino, and I'll be the clerk and timekeeper for tonight's trial. During the trial, I'll be giving visual cues for 2 minutes remaining, 1 minute remaining, 30 seconds remaining, and a verbal and visual cue for stop. At this time, may our teacher coach please introduce herself?
Please.
Thank you.
Good evening, Your Honor. My name is Ann Bookin, and I'm the teacher coach for Team 15.
Okay, thank you. So we've just met the prosecution team. I'm going to invite the defense team to also state your name and the role for the evening.
Good evening, Your Honor. My name is Purvi Thairani, and I represent Jamie Kobe in the pretrial motion. At this time, may the trial attorneys please be allowed to introduce themselves?
Please.
Good evening, Your Honor, and opposing counsel. My name is Karina Ratra, and tonight, along with my co-counsel,
Arhana Mandalam, good evening, Your Honor.
Kushi Bala, good evening, Your Honor.
we represent our client, Jamie Kobe. At this time, may our witnesses please introduce themselves in order of appearance?
Yes, they may.
Good evening, Your Honor. My name is Pulkpreet Kaur, but tonight I'm Dr. Tyler Clay.
Good evening, Your Honor. My name is Ishan Gohel, but tonight I am Danny Emling.
Good evening, Your Honor. My name's Nandini Datta, but tonight I am Francis Yaz.
Good evening, Your Honor. My name is Joycelyn Hutchinson, but tonight I am Jamie Kobe.
Thank you.
At this time, may our courtroom bailiff and unofficial timer please introduce themselves?
Please.
Good evening, Your Honor. My name is Arthur Go, and tonight I will be serving as your courtroom bailiff. I'll keep the court in order. For the convenience of the court, I will be providing the page number of the witness's statement before that witness testifies.
Good evening, Your Honor. My name is Constantine Mamalilis, and tonight I will serve as the courtroom's unofficial timer. I'll be working alongside the clerk to keep time, and I will alert the court of any time discrepancies of 15 seconds or greater.
Thank you.
And finally, Your Honor, may our coaches please introduce themselves?
Please.
Good evening, Your Honor. My name is Glenn Davis, teacher coach.
Good evening, Your Honor. Heather Maringo, coach.
Thank you.
And with that, Your Honor, the defense are ready to proceed.
Thank you. And so now we've been introduced to both teams. And so I just want to make clear, we by this point all know this. You must complete your presentations within the specified time limits. Clerk will signal you as your time for each section of the presentation begins to run out. When your total time for each section runs out, you'll be stopped, even if you haven't finished. Attorneys must call 4 witnesses within time limit. This is a bench trial. At the end of the trial, I will render a verdict of guilty or not guilty in relation to the charges brought. The teams will be rated based on the quality of the presentation, independent of my verdict, thankfully. Barring unforeseen circumstances, there'll be no recesses. If for any reason something happens, everybody just stay in place until we can deal with it. That also comes up with, because we're doing this remotely, there may be technical problems. I ask that everybody, if there develops a technical problem, stop, bring it to our attention, and we'll consult and let you know what to do. Remember that the objections are limited to the California Mock Trial Simplified Rules of Evidence. And so now at this point, if there's no questions or anything else that needs to be brought up, we can begin with the pretrial arguments. Okay, so today, with regard to the pretrial argument, both sides have 4 minutes to present their arguments. Defense begins because they're making the motion. I may interrupt to ask clarifying questions. If I do, time spent answering my questions is not included in the 4-minute time limit. If I don't ask clarifying questions, or if I do, don't take that to mean anything other than that I'm just asking you a question. At the conclusion of your arguments, each side will be offered 2 minutes of rebuttal time. Remember that rebuttal time is to be used to counter your opponent's arguments. It cannot be used to raise new issues. And so at this point, is counsel for the defense ready to begin?
Yes, Your Honor. May I proceed?
Yes, you may.
Thank you. May it please the court. Your Honor, the Fourth Amendment protects citizens' personal liberty and privacy by keeping them safe from unreasonable searches and seizures without warrants, offering protection from unwarranted government surveillance. The prosecution, however, is attempting to deprive my client, Jamie Kobe, of her right to privacy and safety in her own home by trying to admit an illegally obtained piece of evidence, the photo of the snake tongs in Exhibit A and all related bracketed information. However, it is the defense's contention that this evidence cannot be admitted because 1, Jamie Kobe's backyard constituted the curtilage of her home. And 2, Deputy Garrett intruded on an area that was protected by the Fourth Amendment, and the lack of a warrant renders this evidence inadmissible. First, Your Honor, Kobe's backyard constituted the curtilage of her home. For this, we can turn to the Supreme Court case of United States v. Dunn, which sets out a 4-part test to determine whether or not an area constitutes the curtilage of one's home. It tests 1, the proximity of the area to the home, 2, whether or not the area is included in an enclosure surrounding the home, 3, the nature of the uses to which the area is put, and 4, steps taken to protect the area from the observation of people passing by. First, Your Honor, Kobe's backyard was directly attached to the back of her house, fulfilling the first prong. Secondly, she had a 6-foot fence on all sides, meeting the second prong. Third, she used her yard for gardening, an activity she found relaxing, meeting the third prong. And lastly, as I mentioned earlier, she had a 6-foot fence on all sides. A 6-foot fence is taller than most people, so this fence would have efficiently protected her yard from the observation of people passing by. Your Honor, this is in stark contrast to the circumstances of Dunn, in which the area in question was a considerable distance away from the home, was inadequately protected, and was physically separated from the home. In our case at hand, the area is in close proximity, it's directly adjacent, it is included in the same enclosure, regularly used and adequately protected, and as a result must be considered curtilage. Secondly, Your Honor, Deputy Garrett needed a warrant in order to search Kobe's backyard, as it was protected by the Fourth Amendment. For this, we can turn to the Supreme Court case of Katz v. United States, which sets out a 2-pronged test to determine whether or not an area is protected by the Fourth Amendment and whether or not searching it constitutes a Fourth Amendment search. The defendant must 1, exhibit a subjective expectation of privacy that 2, society can deem reasonable. In the case at hand, Kobe exhibited a subjective expectation of privacy by telling Smith they didn't have permission to aim the camera in her backyard and by keeping a 6-foot fence on all sides. But furthermore, Your Honor, this expectation was also objectively reasonable. We can turn to the case of United States v. Romero Bustamante, in which Border Patrol agents entered the defendant's yard without a warrant to arrest undocumented immigrants. However, the judge ruled that this warrantless search of the defendant's yard was a search under the Fourth Amendment as it was protected by it, and as a result, Kobe's yard must be offered the same protections. Furthermore, Your Honor, in the case of United States v. Jones, the judge ruled that physical intrusion is not always necessary for surveillance in the modern day and age. So even though police may not have physically entered Kobe's yard, they still had constant access to activities there for 6 months on end, the non-physical intrusion that Jones is referring to. Your Honor, denying our motion would deprive Kobe of her Fourth Amendment rights and create a precedent that would give the government the vast authority to reach into citizens' private lives and collect any sort of incriminating evidence. Due to these reasons, Your Honor, the defense respectfully requests that Your Honor grant the motion to exclude Exhibit A and all related information from trial today. Thank you.
Okay. Thank you, and I will ask, is counsel for the prosecution ready to begin?
Yes, Your Honor. May I proceed?
You may proceed.
Good evening, Your Honor. The defense's motion should be denied. The recording of the tongs did not violate curtilage rights. The defendant did not have a reasonable expectation of privacy, and the footage falls under the plain view exception, thus not requiring a warrant. Your Honor, the Fourth Amendment protects the home from police search and seizure, including its curtilage. Curtilage is a protected area under the Fourth Amendment, defined under United States v. Dunn with a 4-pronged test. While the backyard arguably passes the first 3 parts of the test, as mentioned by opposing counsel, the steps that truly fails the fourth portion, the steps taken by the resident to protect the area from observation by passersby. While 3 sides of the yard are fenced off, opposing counsel fails to mention that the back wall is uninterrupted by an unlocked chain link gate, which leads out into public state park land. Because of this gate, the yard loses its reasonable expectation of privacy, as the yard can be seen into or walked into by anyone who may be walking past. California v. Serralo states that Fourth Amendment protections regarding the home are not absolute, and ruled that an unobtrusive observation that took place in public navigable airspace was consistent with the Fourth Amendment, as anyone who flew over the defendant's house could have seen exactly what police saw, just like how if the police or anyone else walked through the park, they could have seen exactly what the camera saw. Now, even if you consider this backyard curtilage, it still doesn't have a reasonable expectation of privacy. Under United States v. Katz, Fourth Amendment protections are defined with a two-part test. First, has the person shown an actual expectation of privacy? And second, does society view that expectation as reasonable? The defendant fails to meet the first prong of this test and the second as a result. The defendant was fully aware of the camera as Smith put up a 2 by 3 feet sign that said, "Smile, you're on camera." Kobe knew that this camera was up and recording, and unlike in Schaefer versus City of Boulder, only asked for it to be removed once before saying herself that she forgot about it. Despite knowing about the camera, she took the tongs outside and left them there. The defendant fails both US v. Katz and US v. Dunn, so the defendant does not have a reasonable expectation of privacy. Now, the defense may try to tell you that a similar situation, as in Schaefer versus City of Boulder, was ruled as a violation of the Fourth Amendment, but that case is very different from this one, and the ruling of Boulder, Nevada is not controlling of decisions in this court. While there was a camera pointed at Schaefer's backyard, there was also one pointed into Schaefer's bathroom. The camera in Schaefer's case was also very high quality and came from the Department of Homeland Security, while the camera in this case could easily be purchased at any Best Buy. As well as this, Schaefer had repeatedly asked for the camera to be removed. Finally, and importantly, United States v. Cara was not ruled as a Fourth Amendment violation, as although the cans of ether contained an unwanted object, it was not a meaningful enough interference with the defendant's interest in their privacy. This is similar to this case, as Kobe knew that they were being filmed and did not see it as a meaningful enough interference with her privacy to ask for it to be removed more than once. Your Honor, the defendant did not have a reasonable expectation of privacy. The footage did not violate the defendant's curtilage rights. And if either of these were true, the recording falls under the plain view exception, not requiring a warrant. This is why we ask the defense's motion be denied and the footage of the snake tongs be admitted into evidence. Thank you.
Okay. Now back to the defense. Do you have any rebuttal?
Yes, Your Honor. May I proceed?
Yes, you may.
Thank you. Your Honor, I have a few points to address with opposing counsel's argument. First, Ms. Wilson argued that Kobe's yard is not curtilage, conceding the first 3 prongs of Dunn, but arguing the 4th. Opposing counsel argued that because of the wire link gate at the back, Kobe's yard is not curtilage. Your Honor, we can again reference the case of United States v. Romero-Bustamante for this. The defendant of this case had a brick wall surrounding their property, but in parts, a wire link gate similar to Kobe's. However, the judge still considered it curtilage, and as a result, Kobe's yard must also be offered the same protections. Kobe's gate was just 12 square feet, a negligible portion of her 1 acre or 44,000 square foot property that is fenced in. This, as per Romero-Bustamante, does not constitute inadequate protection, and her yard is curtilage as per the test. Secondly, opposing counsel argued that Kobe did not take enough measures to have the camera taken down. She, however, explicitly expressed her disapproval of the camera and subsequently forgot. She had other things on her mind, such as her sick mother and the recent loss of her job. Opposing counsel also argued that the case of Schaefer was more intrusive than our own. However, Your Honor, neither the footage from the backyard nor the bathroom was entered into trial in Schaefer, meaning that the backyard is still an intrusive search. Lastly, opposing counsel argued that because no meaningful interference took place with Kobe's property, a Fourth Amendment search did not occur. However, Your Honor, we can turn to the case of Jones, in which the defendant could still use their car, was able to fully operate it, but this was still a Fourth Amendment search because it was unconstitutional and required a warrant to do so. Your Honor, opposing counsel is putting a severe burden on the public to protect their own rights. However, this is a line that Garrett was meant to operate within, but did not. As per People v. Weaver, we must offer judicial oversight to avoid the unacceptable possibility of the government misusing modern technology in order to conduct such searches. Your Honor, please grant the defense's motion to exclude Exhibit A from trial today. Thank you.
Thank you. And now rebuttal from the prosecution.
Your Honor, the defense makes several points that I would like to address.
Mhm.
Firstly, they bring up Romero, the case of United States versus Romero Bustamante, but they fail to mention that in that case, a physical intrusion was made by the officers, which is why the court ruled it a violation of the Fourth Amendment. They also bring up the fact that Kobe had only asked for the camera to be removed once, and that should be enough in their opinion. However, Schaefer sets the precedent for this, as the defendant and Schaefer took many steps to protect their home. They asked for their neighbors to remove the camera on several occasions. They called the police, and they even built their fence higher to prevent the camera's view. As well as this, defense brings up the case of United States v. Jones, which, unlike this case, was a case involving a GPS tracker, which are very different circumstances from this one. And finally, the defense brings up the case of People versus Weaver, which is a court made in a New York court, again, not controlling of decisions here. So again, the people ask that the defense's motion be denied and the footage of the snake tongs be admitted into evidence. Thank you.
Okay, before I make a ruling, does either side wish to note any irregularities, or wish a moment to confer about that? Okay. Yes.
Your Honor, the defense finds no trial irregularities.
The prosecution also finds no trial irregularities.
Okay. I've considered the arguments that have been made, and I'm going to grant the motion and exclude the evidence. And so at this point, we're going to begin with the presentation of evidence and beginning of the trial. So first, we begin with an inquiry of starting with the prosecution, do you have any physical evidence that you want to present?
Yes, Your Honor. The people would like to present exhibits B through E and make sure that they are properly identified and have been shown to opposing counsel.
Okay. Any objections from the defense?
No objections, Your Honor.
Okay. This is so different than when we do it in person, where you actually would bring it out and we would show each other. But yes, okay. And so those will be admitted, and well, those will be identified and marked. They're not admitted at this point. And so at this point, and does the defense have any additional physical evidence that you want to present?
No additional evidence, Your
Honor. So we're here today because the people of the state of California are charging the defendant, Jamie Kobe, with first-degree murder or voluntary manslaughter of Eric Smith. At this point, is the prosecution ready for opening statement?
Yes, Your Honor.
You may proceed.
I am going to kill him. There was motive, and there was murder. A few hours after the emotional funeral, Jamie Kobe had only one thing on her mind: to get rid of Eric Smith. Jamie Kobe was a tenant of Eric Smith's and had lived next to him on Raptor Road for 10 years. The defendant is a well-known gardener in the desert community and therefore is familiar with and has knowledge of snakes and how to handle them. Now, Jamie Kobe did not get along with Eric Smith, but since rent was low, the defendant stayed. Tensions between Eric Smith and Jamie Kobe reached their tipping point when Eric Smith cut off the defendant's power, which cut off the defendant's mother's life-supporting oxygen, which led to her death. Jamie Kobe blamed Eric Smith for her mother's death. A few days later, at the defendant's mother's funeral, Eric Smith showed up uninvited. That night, a neighbor heard Jamie Kobe yell, "I am going to kill him." The next day at 8:30 a.m., Jamie Kobe was seen at Eric Smith's mailbox holding an animal cage. Your Honor, not 4 hours later, when Eric Smith reached into this same mailbox, he was bitten by a Mojave rattlesnake, the deadliest rattlesnake in North America. Because of this snake bite, Eric Smith is dead. Based on this evidence, the people have charged Jamie Kobe with first-degree murder. Tonight, we will meet our burden and prove beyond a reasonable doubt that Jamie Kobe committed first-degree murder. The witnesses we will call to the stand will testify that what Jamie planned and what Jamie did was nothing short of first-degree murder. Angel Russell, the line worker who found Mr. Smith dead, will testify that he saw Jamie Kobe walk up to Eric Smith's mailbox holding an animal cage. Mr. Russell also saw Eric Smith and helped him after the snake bite. Deputy Sheriff Tony Garrett will testify that he found several items in the defendant's house pointing towards them as a suspect. Terry Edwards, a neighbor, will testify that on the night of the funeral, he heard Jamie Kobe yell 6 words: "I am going to kill him." Finally, Dr. Charlie Dunn, the county medical examiner, will testify that Eric Smith died from the Mojave rattlesnake's venom. Your Honor, after we have proven this, the prosecution will have met the burden of proof and proven beyond a reasonable doubt that Jamie Kobe committed first-degree murder. We ask you to find the defendant guilty. Thank you.
Okay, now for the defense, opening statement.
Yes, Your Honor. May I proceed?
Yes, you may.
April 29th, 2021. Eric Smith goes to his mailbox. As he opens the door, a snake coiled in the box bites his left wrist. The next day, April 30th, Eric Smith is pronounced dead. Now, Your Honor, you might be wondering, how did the snake get into the mailbox in the first place? It was just seeking the shade. And no one maliciously put the snake in the box or intended to harm Mr. Smith in any way. There was no motive, there was no murder. Because, Your Honor, in today's case, revenge did not kill Mr. Smith. Nature did. So let's take a few steps back and talk more about the evidence that you'll hear today. First, you'll hear from Dr. Tyler Clay. Dr. Clay is an expert in herpetology and will tell you that it is highly possible for the snake to have crawled into the mailbox on its own accord. She will tell you that Mojave rattlesnakes are extremely common during the months of April through October, and they often like to seek shade during the hot months of the year. Next, you'll hear from one of Ms. Kobe's neighbors, Danny Emling, who will tell you that Jamie always cooled down after she had arguments with Mr. Smith. Third, you'll hear from Ms. Kobe's close friend and neighbor, Francis Yazzie, who will tell you that Jamie is a kind person. And despite arguments with Mr. Smith, including one at the funeral of Jamie's mother, Jamie always calmed down and reverted back to her gentle and even-tempered self. Finally, you will hear from the defendant, Jamie Kobe herself, who will take the stand today and tell you that she struggled during the pandemic. She lost her job, and her mother passed away due to Eric turning off the electricity which connected to her mother's oxygen. And yet, despite all of this, she will tell you that she still did not blame Eric fully for the death of her mother. Miss Kobe will tell you exactly what she meant by the statement, "I am going to kill them," while she was gardening at her home. You will hear that the statement was directed towards the snails and the rabbits in her garden. Your Honor, nothing more. Today, the people have charged Jamie Kobe with first-degree murder or voluntary manslaughter. In doing so, the people have brought upon themselves a burden to prove every element of this case beyond a reasonable doubt. And by the end of this trial, it will be apparent that the people have simply brought upon themselves a burden that they cannot meet. Today, the people will paint a story of motive and murder. But, Your Honor, the facts in today's case will show only the opposite. No motive, no murder. Because revenge did not kill Mr. Smith. Nature did. And at the end of this trial, my co-counsel, Ms. Ratra, will be asking you for the only just verdict of not guilty. Thank you.
Okay, we have now heard the opening statements from the parties. And so at this point, we're going to begin with the presentation of witnesses. And so the prosecution may call their first witness.
Thank you, Your Honor. At this time, the people call Angel Russell to the stand.
Angel Russell, please turn on your camera and microphone. Angel Russell, please confirm that you can see and hear me.
Yes, I can see and hear you.
Please raise your right hand. Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
Please state your full name, spelling out your last for the record.
Angel Russell, Russell.
Your Honor, this witness's statement is located on pages 36 to 37 of the mock trial case packet.
Okay. You may examine the witness.
Thank you, Your Honor. Good evening, Mr. Russell. Would you please introduce yourself to the court?
Good evening. My name is Angel Russell, and I've been a line worker in Burnsley County for the past 15 years.
And how are you involved in this case?
So I actually saw Eric Smith get bitten by a snake, and then I was also the one who found him the next day.
Now, Mr. Russell, I want to draw your attention to April 29th, 2021. What were you doing that day?
I was working on a power line just down the road from Eric Smith's house that day.
And did you notice anything unusual while you were working that day?
I did actually. Early that morning, about 8 a.m., I saw someone come out of the house just down the road. They were carrying a pretty bulky bag and a wire cage that they looked down at several times.
Do you know who the person holding that wire cage was?
Yes, I later learned they were Jamie Kobe.
And what did the defendant do after you saw them leave their house?
Well, I saw them walking up to the mailboxes in front of the houses. I saw them standing right next to them.
Now, Mr. Russell, I'm going to show you what has previously been marked Exhibit E. Your Honor, may the clerk please display it on the screen?
Yes, please do.
Mr. Russell, do you recognize this? Sorry, Exhibit E. Thank you, clerk. Mr. Russell, do you recognize this?
Oh yeah, that was the wire cage that I saw Jamie Kobe carrying.
And is this a fair and accurate description of the wire cage you saw Jamie Kobe holding?
Yes, it was.
Your Honor, at this time, people move Exhibit E into evidence as People's Exhibit E.
Any objection?
No objections from the defense, Your Honor.
Okay, that'll be admitted then.
Your Honor, people ask the clerk to please stop screen sharing this at the time.
Okay, please do.
Thank you. Mr. Russell, did you see anyone else go to Eric Smith's mailbox that day?
I did actually. I saw Eric Smith himself walk out of his house and up to the mailboxes.
And what happened when he got to the mailbox?
Well, when he got there, he opened the mailbox door, he reached in, and then suddenly he stepped back and screamed. I saw a snake attached to his wrist, and I think I saw a few envelopes fall to the ground.
And what did you do in response to this?
I started panicking and I rushed over to him. You know, I saw him groaning on the ground and I saw the snake. So I thought maybe I should try to kill it with something. I ran over to my truck and picked up a breaker bar.
And did you manage to kill the snake?
I did actually. When I came back, I just hit the snake until I killed it and kicked it into some shrubs.
And what was Mr. Smith doing during this entire process?
Well, I remember when I came back with the bar, he stood up and he screamed, "Jamie!"
And what did Mr. Smith do after he yelled, "Jamie"?
I think he just picked up the envelopes that he had dropped. I told him he should go to the doctor, but he insisted he was okay. So he just walked back inside.
Your Honor, permission for the clerk to screen share what is previously marked as Exhibit D.
Please do.
Mr. Russell, do you recognize this? Ooh, looks like we're having some technical difficulties. Round 2 of the evening. Mr. Russell, do you recognize this?
Yeah, that's the snake that I killed, the same one that bit Eric Smith.
And is this a fair and accurate representation of the snake that you killed?
Yes, it is.
Your Honor, at this time, the people move Exhibit D into evidence as People's Exhibit D.
Any objection?
No objections from the defense, Your Honor.
Still be admitted.
Now, Mr. Russell, is there anything you noticed specifically about this snake?
Yeah, I could tell that it was a rattlesnake, but it's odd. It doesn't have a rattle attached to it.
Mr. Clerk, will you please remove the exhibit, bring down the exhibit? Thank you. Now, Mr. Russell, did you ever see Mr. Smith again?
I did, actually. I came back to work the next morning to keep working on the power line, and that's when I saw him again. I apologize. When I came back the next morning, like I said, I saw Eric Smith. He was lying in his front yard, face down. His pajamas were still on.
And what did you do?
I ran over to him and I started checking for a pulse, but I didn't find anything. So I called 911 and I just yelled for help.
Mr. Russell, did anyone respond to your calls for help?
No, nobody came.
Thank you, Your Honor. No further questions at this time.
Okay, the witness is available for cross-examination.
Yes, Your Honor. May I proceed?
Please.
Good evening, Mr. Russell.
Good evening.
I'd like to first start off by talking about something that you stated on direct examination. You stated that you saw Miss Kobe at Eric Smith's mailbox at 8 a.m.
I think it was a bit more like 8:30. It was right after I got to work.
All right, Mr. Russell. And let's talk a bit about what you saw at that time. At the time you saw Miss Kobe was wearing a long sleeve t-shirt?
Yes, she was.
But nowhere in your witness statement do you mention seeing Miss Kobe wearing any gloves, am I correct?
I don't recall any gloves.
Nowhere in your witness statement do you mention seeing Miss Kobe carrying any tongs?
I only saw a bag and a cage, but I didn't see any tongs.
Objection, Your Honor.
Again.
Due to your pretrial ruling, any evidence including tongs, I believe, has been taken out.
Your Honor, if it may be heard.
Yes, please.
In the pretrial ruling, any evidence relating to the tongs in the image were related. Now, I'm not asking about that image, but rather that this witness doesn't mention anywhere in their statement that they did see tongs. It's an entirely unrelated matter, Your Honor.
Your Honor, may I be heard?
Go ahead, please.
Any other testimony throughout the entirety of the trial in any regards to the tongs is in brackets regarding, essentially inferring that if the pretrial matter is lost, that any information regarding the tongs are taken out and not used.
Your Honor, if it may be heard.
Please.
This witness doesn't say it anywhere in their statement that they saw these tongs. Now, I'm not asking about anything that was in brackets, rather the fact that this isn't in their witness statement, Your Honor.
Your Honor, I would like to amend my objection to unfair extrapolation.
Your Honor, if I may be heard on that point?
Please, go ahead.
Unfair extrapolation is the creation of a material fact. In this case, I'm highlighting that nowhere in this witness's statement do they mention these tongs. That is not the creation of a material fact, but pointing out the lack of said fact.
Your Honor, may I be heard?
Go ahead.
Whether or not these tongs are involved would indeed be creating material fact, as I believe counsel is going to use this information to essentially infer the method of transportation of the snake to the mailbox, which is a material effect and would directly results the decision of this case.
Okay, sustained.
May I proceed, Your Honor?
Go ahead.
Now, Ms. Russell, you mentioned that you saw Ms. Kobe carrying the cage.
Yeah, they looked down at it several times.
You saw this from about 100 feet away.
Yeah, about 100 feet, just at the power line.
But Ms. Russell, you don't remember if there was anything in this cage, do you?
I didn't see anything, no. There could have been.
You don't remember if there was, for example, a snake in that cage?
I didn't see a snake in the cage.
And the only time that you saw a snake that day was when one bit Eric Smith. Yes?
Yeah, I recall it very well. I saw it bite Eric Smith. I also killed it.
Moving on, I'd like to talk to you about the events after that. After you killed the snake, you checked on Mr. Smith?
Yeah, I actually, at one point, tried sucking the venom out of his wound, thinking it would help.
You noticed some envelopes on the ground.
I did. I saw them fall when he actually opened the mailbox.
You can't tell the court today how many envelopes were on that ground, can you, Mr. Russell?
I can't give an exact number, but it was a few.
But you did see Mr. Smith take these envelopes into his home?
He did.
But you don't know what he did with those envelopes inside his home, do you?
No, of course I don't.
Thank you, Mr. Russell. Thank you, Your Honor. No further questions for this witness.
Okay, redirect?
No redirect, Your Honor. At this time, may this witness please be excused?
Yes. Okay, you may call your next witness.
Your Honor, we the people call Deputy Sheriff Tony Garrett to the stand.
Deputy Sheriff Tony Garrett, please turn on your camera and microphone. Deputy Sheriff Tony Garrett, please confirm that you can see and hear me.
I can, yes.
Please raise your right hand. Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
Please state your full name, spelling out your last for the record.
Tony Garrett, that's Garrett.
Your Honor, this witness's statement is located on pages 31 to 35 of the mock trial case packet.
Okay, you may examine the witness now.
Good evening, Officer Garrett. Could you please introduce yourself to the court?
Good evening. My name is Tony Garrett, and I'm a deputy sheriff here in Burnsley. I'm here today because I responded to the call about Eric Smith's death.
Did you know Eric Smith?
I did, yes. I've known Eric Smith for the whole time I've been a deputy sheriff here in Burnsley. I believe he was a contractor who later became a landlord.
And did you know Jamie Kobe, the defendant?
I did, yes. I first became aware of Jamie Kobe when they moved here with their mother about 10 years ago.
Did you ever receive calls from either of them?
Oh, yes. I received lots of calls from both of them. I believe the first one was about 4 years ago.
Earlier, you said that you were the one to respond to Eric Smith's death. When was this?
The call was on April 30th, 2021 at approximately 8:40 a.m. It was to 46601 Raptor Road.
When you got there, what did you find at the scene?
At the scene, I found Angel Russell, the line worker, standing next to Smith's face-down body.
What had happened?
Well, I first did a quick pulse check, but I was unable to find one. However, I did notice very distinctive puncture marks on Smith's left wrist that looked to be from a rattlesnake. I then did a visual inspection of the body and interviewed Angel Russell.
After you investigated the body and interviewed Angel Russell, what was your next step in your investigation?
Well, my next step was to investigate Smith's home.
And what did you find in Mr. Smith's house?
In Smith's home, I found 3 envelopes. I later learned that these contained rent checks from all of Smith's renters except for Kobe.
And did you investigate the defendant's house?
I did, yes.
And what did you find in the defendant's house?
In the defendant's home, I found multiple books on venomous snakes and another on poisonous desert animals. I then found a small tub on the shelf, which contained what appeared to be about 5 rattlesnake rattles. I also found a small vial of liquid with a handwritten label reading anti-venom.
Did you do anything else in your investigation?
Yes, I then investigated the defendant's garage.
What did you find in the defendant's garage?
I found a small table on which I found animal handling gloves, a long sleeve t-shirt, and what I recognized to be snake-proof boots.
Did you arrest the defendant?
Yes, I did on June 3rd, 2021.
Thank you. No further questions at this time.
Okay, the witness is now available for cross-examination.
Yes, Your Honor. May I proceed?
Yes, you may.
Good evening, Deputy Garrett.
Good evening.
I'd like to start by talking to you about Eric Smith. And now on direct examination, you mentioned that you're pretty familiar with Mr. Smith, correct?
Yes, I've known him for about 20 years.
You also mentioned that you're fairly aware of Jamie Kobe.
Yes.
And you're aware of the relationship between Miss Kobe and Mr. Smith, correct?
Well, I think everybody was.
In fact, Deputy, you had to respond to at least half a dozen calls from either of them complaining about the other, right?
They would often call and complain about each other, yes.
I'd like to talk to you about one of the specific instances that you responded to. Last October, you received a call from Smith in which he suspected that Miss Kobe had broken into his house, correct?
That's correct, yes.
And just to be clear, Deputy, you did not find any evidence of this, correct?
There was no physical evidence, no.
And despite not finding any evidence, you provided Mr. Smith with a camera that looked into Jamie Kobe's backyard, correct?
Well, it is my job as a deputy sheriff to keep my council members safe. So when Eric Smith requested a camera, I gave him one.
This was despite not finding any evidence of the break-in, right, Miss Deputy Garrett?
That's right, yes.
And you did not give a camera to Miss Kobe?
To my knowledge, Kobe did not feel unsafe and did not request one, so I did not feel it was necessary.
I want to talk to you about April 30th, 2021. You responded to a call at 46601 Raptor Road, correct?
Correct, yes.
You found Mr. Smith? You found Mr. Smith, right, Deputy Garrett?
I did, yes.
And after escorting Mr. Smith to the hospital, when unfortunately he was pronounced dead, you returned back to the scene, correct?
I did, yes. I felt there was further investigation that could be done.
And you spoke to Angel Russell, who you had met earlier when you first arrived?
Yes, I interviewed Mr. Russell.
Just to be clear, Deputy, from your knowledge, Mr. Russell was the only person who you talked to that, again, from your knowledge, was at the scene when Mr. Smith was bit, correct?
That's right, yes.
And Mr. Russell told you that they saw a person identified as Jamie Kobe in front of the mailbox carrying a bag in a wild-looking cage, right?
That's right, yes.
And that was all the information that you received about this person from Mr. Russell?
From Mr. Russell, yes.
So, Deputy, solely based on what Angel Russell told you, who was the only person you spoke to at the scene of the crime, it is uncertain to determine what exactly that person was doing at the mailbox, correct?
Well, Mr. Russell was at the scene and did see Jamie Kobe at the mailbox, so that's not exactly true.
Deputy Garrett, you could say for certain that what that person was doing at the mailbox just by interviewing Angel Russell?
Yes.
Deputy Garrett, all Angel Russell told you was that the person was carrying a bag in a wild-looking cage, right?
That's right, yes.
Moving on, Deputy, you eventually did search the residence of Jamie Kobe, correct?
I did, yes. I felt it was very necessary.
You searched the living room?
Yes.
And you glanced at the garage, correct?
Yes, I investigated the garage.
You glanced at it, right, Deputy?
Sure.
And this is all that you stated to search in your witness statement, correct?
That's correct.
So just to be clear, Deputy, you did not search the entire residence of Jamie Kobe, who you later arrested, correct?
That sounds about right, but I did not feel the entire thing was necessary.
That's a yes to my question, Deputy.
That is a yes.
Thank you, Deputy Garrett. Thank you, Your Honor. No further questions.
Any redirect?
Yes, Your Honor. Officer Garrett, why did you give Eric Smith a camera?
Well, as I stated before, Eric requested it and felt very unsafe. So I felt it was my job to protect him, and I provided him with the camera.
Officer Garrett, did you conduct a thorough investigation?
I did, yes.
And why did you arrest Jamie Kobe?
Well, I found a lot of very suspicious activity in Jamie Kobe's house, and I found a lot of suspicious things in his house.
Thank you. No further questions at this time.
Okay. The witness, I guess, would be excused, and you can call your next witness. Right?
Apologies. The people called Terry Edwards to the stand.
Terry Edwards, please turn on your camera and microphone. Terry Edwards, please confirm that you can see and hear me.
I can see and hear you.
Please raise your right hand. Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
Please state your full name, spelling out your last for the record.
Terry Edwards, EDWARDS.
Your Honor, this witness's statement is located on pages 38 to 39 of the mock trial case packet.
Okay, you can proceed.
Good evening, Mr. Edwards. Could you please introduce yourself to the court?
Hello, my name is Terry Edwards, and I am Eric and Jamie's neighbor.
And how long have you known Eric Smith?
I've known Eric for a while, a long time. I mean, it's probably been 10 years now that I've lived down Rapid Road from him. Yeah.
And did you know Jamie Kobe, the defendant?
I do know Jamie. I live right near her. I was there when her and her mom moved in.
Did you attend Jamie Kobe's mother's funeral?
You know what I did? I figured that because it was a small town, that I'd drop by and pay my condolences.
And at the funeral, what did you observe about Kobe's behavior?
Well, Jamie seemed angry, and I mean, at one point I overheard her talking to people, saying things like this was it, and that she was finally going to do it.
At the funeral, did you see Eric Smith?
I did see Eric. He seemed civil, just like the rest of us.
And did anything unusual happen at the funeral?
Well, yeah, something did. I remember at one point in the funeral, I hear all this commotion coming from outside the church. And I go outside, and Eric and Jamie are actually yelling at each other in a fight. And I mean, come on, guys, this is a funeral. Let's get it together.
And after the funeral, what did you do?
Well, after the funeral, judging from what happened, I mean, who knows how Jamie was feeling. So I would think it was around dusk. I decided to drop by, check in on Jamie. As I pull up to her residence, before I could even say anything, I suddenly hear her scream, "I'm going to kill him."
Thank you. No further questions at this time.
Okay, the witness is available for cross-examination.
Yes, Your Honor, may I proceed?
Please do.
Good evening, Mr. Edwards.
Good evening.
I'd like to start off by talking about your relationship with Jamie Kobe. Mr. Edwards, you two don't have the best relationship, do you?
Truthfully, no, not the best.
In your own words, you would describe Miss Kobe as a real pain.
Jamie could be a real pain sometimes, yeah.
In fact, you viewed some of her actions as unacceptable, didn't you?
Yeah, some of her actions were unacceptable, in my opinion.
And you're here testifying for the prosecution against this very person, Jamie Kobe, aren't you?
I am. I'm telling the truth, and I'm here to testify.
Moving on, I'd like to direct your attention to the day, April 28th, 2021. The evening that day, you drove by Miss Kobe's house to check on her?
I did. I mean, while I was going up to check on her, judging from what happened on the funeral, I had no idea how she was feeling.
And that evening, you heard Miss Kobe say, "I'm going to kill him." Am I correct?
Those exact words, yes.
When you heard this, you were still in your car. Am I correct?
I was in my car.
While Miss Kobe was all the way in her garden?
Yes, I mean, the window was rolled down and she screamed it. And so, yeah, I heard those 6 words.
And you did end up speaking to Miss Kobe. Am I correct?
Yes, I did.
At which point you didn't even think to ask her about this statement, did you?
Well, I mean, judging from what happened at the funeral, like I've been saying, she didn't seem really okay. And so I just didn't think that, I didn't think of the statement as anything important. No.
Mr. Russell, Mr. Edwards, that wasn't my question. My question was that you didn't ask her about this statement, did you?
No, I did not.
And in fact, you chose to ignore it.
I did ignore it.
Thank you, Mr. Edwards. Thank you, Your Honor. No further questions for this witness.
Okay, redirect.
Yes, Your Honor. Mr. Edwards, why did you go to Jamie's house?
I mean, like I've been saying, Jamie, judging from what happened, I mean, to anyone, she didn't seem okay. Who knows how she was feeling. And yeah, I'm a good neighbor and I just wanted to be there for her. So I went to go check up on her.
Thank you. No further questions.
Okay, thank you. This witness may be excused. And I guess the people may call, I guess it's your last witness?
The prosecution would like to call Dr. Charlie Dunn to the stand.
Dr. Charlie Dunn, please turn on your camera and microphone. Dr. Charlie Dunn, please confirm that you can see and hear me.
I can see and hear you.
Please raise your right hand. Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
Please state your full name, spelling out your last for the record.
Dr. Charlie Dunn, D-U-N-N.
Your Honor, this witness's statement is located on pages 29 to 30 of the mock trial case packet.
Okay. Okay, so the witness is available for questioning.
Good evening, Dr. Dunn. Could you please introduce yourself to the court?
Hello, my name is Dr. Charlotte Dunn, but everybody calls me Charlie. I am the Chief Medical Examiner for Burnsley County. I conducted Mr. Smith's autopsy.
And what are your credentials for this case?
Well, I've always had an interest in venomous animals, especially ones that live in the desert. So after graduating medical school, I went on to complete a residency specializing in clinical toxicology and a fellowship specializing in forensic toxicology, where I became very familiar with venomous and poisonous animals such as snakes and spiders.
And earlier you mentioned you conducted Mr. Smith's autopsy. How did you go about that?
I started by performing a visual examination of the outside of the victim's body.
And what did you find in this visual examination?
I found that Mr. Smith had 2 puncture wounds on his left wrist, and the skin around those wounds was red and swollen. I could tell that this was from a snake bite.
And did you do anything after the visual examination?
After the visual examination of the outside of the body, I moved on to the internal examination.
In the internal examination, did you find anything regarding Mr. Smith's cause of death?
Yes, I found that Mr. Smith's heart had experienced epicardial hemorrhaging, which causes bleeding of the membrane surrounding the heart. The hemorrhaging was an effect of the snake venom.
Snake venom. What snake's venom was this from?
It was the Mojave rattlesnake, which is one of the deadliest rattlesnakes in North America. Its venom is 16 times more potent than that of other rattlesnakes.
And just what is so potent about this snake's venom?
Well, the snake's venom contains neurotoxins, which attack both the nervous system and the respiratory system. And when these toxins enter the human body, they can cause paralysis and unconsciousness, often interfering with the state of mind of the victim and causing them to feel relatively fine, which is extremely dangerous because it could lead the victim to believe that they do not need to seek immediate medical attention, which is completely false.
I'm now going to show what has been previously admitted as Exhibit D. Will the clerk please screen share that exhibit? Dr. Dunn, do you recognize this image?
Yes, that is the Mojave rattlesnake that I was given to perform a visual examination on. It is the snake that bit Mr. Smith.
Thank you, clerk. And how did the bite of this snake cause Mr. Smith's death?
Well, here, let me show you. See, when the snake bit Mr. Smith right here on his left wrist, it emitted hemotoxins into Smith's body. Hemotoxins are toxins that destroy red blood cells and cause thinning of the blood. Now, those toxins made their way up the bloodstream and into the heart, resulting in epicardial hemorrhaging.
And Dr. Dunn, you've read Tyler Clay's statement. Do you agree with the conclusion he made?
No, I do not.
And why is that?
Well, I understood Dr. Clay's conclusions to be that Mr. Smith's death was a result of his pre-existing medical condition, which I know is false because although snake venom can exacerbate pre-existing medical conditions, in this case, Mr. Smith's death was caused by the epicardial hemorrhaging, which was a direct result of the hemotoxins in the snake's venom.
Thank you, Dr. Dunn. No further questions.
Okay, the witness available for cross-examination.
Yes, Your Honor. May I proceed?
Yes, you may.
Good evening, Dr. Dunn.
Good evening.
I want to start by talking to you about your experience as Chief Medical Examiner for Bernsley County. Now, during your experience, you've seen 3 deaths from venomous bites, is that right?
Deaths from venomous bites are rare, so yes.
But only 1 from a snake, correct?
Correct.
And you found that it's rare for one to die from a rattlesnake bite. Do I have that right?
Yes, because antivenom is widely available.
Right, doctor. And in today's case, Mr. Smith didn't receive antivenom. Do I have that right?
Well, Mr. Smith most likely felt relatively fine, so he probably didn't feel the need for antivenom.
Doctor said yes to my question. He didn't receive antivenom?
No, he did not.
Now I want to move on to the snake in today's case. Now you have some knowledge of desert snakes, right?
Yes, I do.
And you're aware that desert snakes are known to squeeze into tight spaces. Do I have that right?
Usually in between rocks and in crevices, yes.
Right, and you mentioned on direct examination that the rattle was missing.
The rattle was missing, yes.
But you don't know for sure how it lost its rattle?
I can't know for sure.
But you do know that it's possible for snakes to lose their rattles naturally, in nature, right?
It would take a good amount of force, but it is possible.
Now, at the end of the day, you can tell us that Eric Smith was bitten by a Mojave rattlesnake, right?
Yes.
But you can't tell us for sure how that snake got into the mailbox.
No.
You don't know if that snake had been in a wild cage?
I can't tell based on my visual examination of it.
And you can't even tell us for sure if someone had placed that snake into the mailbox?
Based on my visual examination of it, no.
Thank you, doctor. Thank you, Your Honor. I have no further questions.
Thank you very much. The witness is excused. Okay, that completes the 4 witnesses for the prosecution. The defense may now call their first witness.
Apologies, Your Honor. The prosecution rests.
Okay, sorry. Yes, sorry. The prosecution rests.
At this time, the defense calls Dr. Tyler Clay to the witness stand.
Dr. Tyler Clay, please turn on your camera and microphone. Dr. Tyler Clay, please confirm that you can see and hear me.
Yes, I can.
Please raise your right hand. Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
Please state your full name, spelling out your last for the record.
Dr. Tyler Clay, C-L-A-Y.
Your Honor, this witness's statement is located on pages 47 to 49 of the mock trial case packet.
Okay. You may proceed with examining your witness.
Yes, Your Honor. Good evening, Doctor.
Good evening.
Could you please introduce yourself to the court?
Yes, my name is Dr. Tyler Clay, and I'm the director of the Southland Zoological Museum in California.
What field are you an expert in?
Well, I earned my PhD from the University of Central California in biology and specialized in herpetology, which makes me an expert on the topic of snakes.
Now, Doctor, how are you involved in today's case?
I have examined both Dr. Dunn's reports on Eric Smith's death, as well as a Mojave rattlesnake specimen that bit him.
Do you agree with everything Dr. Dunn said?
Somewhat. While I do agree with some of Dr. Dunn's conclusions, I disagree with some of the points brought up in Dr. Dunn's review.
Can you elaborate on what you and Dr. Dunn agree on?
Of course. I concur with Dr. Dunn that the wound on Mr. Smith's wrist was from a bite of a Mojave rattlesnake, and we also both agree that Mr. Smith should have received immediate medical attention.
What do you and Dr. Dunn disagree on?
I disagree with Dr. Dunn on two main points. First, on how the rattle of the rattlesnake came off, and second, and most importantly, how the snake crawled into the mailbox.
I'd like to direct the court's attention to what has previously been marked and entered into evidence as Exhibit D. Are you familiar with this exhibit?
Yes, I am.
What is it?
This is a picture of one of my favorite species. It is a picture of the Mojave rattlesnake that bit Mr. Smith.
And what's so significant about it being a Mojave rattlesnake?
The venom of the Mojave rattlesnake is 16 times more potent than any other rattlesnake species. Because of the dangerous nature of the Mojave rattlesnake, I recommend using bite-resistant gloves as they are the only way to ensure safety when handling rattlesnakes. But even with the glove, it is still risky to handle this snake as they can become aggressive when disturbed.
Now, can you elaborate on the first point you mentioned earlier, the rattle?
Yes, as shown in the exhibit, the rattle of the rattlesnake is missing. In my professional opinion, the snake's rattle could have come off naturally. Snakes' rattles are made out of keratin, the same material as your hair and your nails, and just like your nails, they're relatively easy to break. It is actually more common than you think for a rattlesnake to lose its rattle.
Thank you, Doctor. And I'd like to direct your attention to what has previously been marked as Exhibit B. Are you familiar with this exhibit?
Yes, I am.
What is it?
This is a picture of Mr. Smith's mailbox.
Is it a fair and accurate depiction?
Yes, it is.
Your Honor, the defense moves Exhibit B into evidence.
Any objection?
No objections, Your Honor.
Okay, that'll be admitted.
Yes, Your Honor. Now, Doctor, would you elaborate on your second point, the mailbox?
Yes. Rattlesnakes are known to squeeze into tight and dark enclosed spaces to seek shade and rest. Therefore, it is not that unusual for snakes to crawl into mailboxes. This incident also happened in April, when the snakes are the most active, so it is highly likely that the snake behaved in this manner.
Doctor, have you seen any cases similar to the one we have today?
Yes, actually, I've seen a couple of cases before in which a snake has crawled into a mailbox and attacked whoever opened the mailbox.
Now, Doctor, what is your final conclusion for today's case?
My final conclusions are that the snake lost its rattle on its own and that the snake also climbed into the mailbox on its own accord.
Thank you, Doctor. Thank you, Your Honor. I have no further questions at this time.
Okay, the witness is available for cross-examination.
Good evening, Dr. Clay.
Good evening.
You have a specialized education in herpetology, correct?
Yes, that's correct. That's my specialty.
You do not, however, have a degree in medicine. Am I right?
That's correct. That's not my specialty.
You also did not examine Mr. Smith's body in this case, correct?
No, I did not. I just reviewed the reports of Dr. Dunn's reports on Eric Smith's death.
But despite all of these conditions, you came to a different conclusion than the medical examiner's report, correct?
Yes, that's correct.
Your opinion is that Mr. Smith died from pre-existing medical conditions, right?
Yes, I believe that the snake was still the cause of death, but I believe that the venom exacerbated his conditions.
And Dr. Clay, you also did not attend medical school, correct?
Yes, that's correct.
And you did not see the snake bite on Mr. Smith, correct?
No, I did not.
You did, however, examine the body of the dead snake, right?
Yes, that's correct.
And you concurred that this was a Mojave rattlesnake, right?
Yes, that's correct.
Dr. Clay, snakes typically wait until the sun goes down to come out, around dusk, correct?
Yes, that's correct. During the day, they prefer to stay out of the sun and to find a nice space in the shade to rest.
But Dr. Dunn, you are aware of the fact that it was the same temperature inside the mailbox where the Mojave rattlesnake was as it was in the surrounding area, correct?
Even though the temperatures were the same, the sun was still out, so snakes are known to stay out of the sun during the day and to hide into shaded areas, and the mailbox is one of the perfect places for that. So yes, even though the temperatures were the same.
But bringing you back to my question, the temperature was the same both in and outside of the mailbox, correct?
Yes, that's correct, but the snake could have been in the mailbox to stay out of the sun and to get some rest in the shade.
Bringing you back to the snake in question, Mojave rattlesnakes are quite venomous, correct?
Yes, that's correct.
In fact, they are the most venomous snake in North America. Is that right?
That's correct. The venom of the snake is 16 times more potent than any other rattlesnake species.
And the venom in question contains neurotoxins. Is that right?
From what I know, that is correct.
And the neurotoxins in the venom contain chemicals that attack a victim's nerve tissue, correct?
Yes, that is correct.
And this venom can also cause cardiac arrest in a victim. Is that right?
Objection, improper expert opinion. Your Honor, may I be heard?
Yes.
Your Honor, opposing counsel previously asked this witness questions about how she's not a medical expert, and therefore she can't answer the questions opposing counsel are asking her about neurotoxins.
Your Honor, may I respond?
Please go ahead.
I'm specifically asking this expert about neurotoxins inside of a snake's venom. This expert has testified to being an expert in herpetology and has testified to having a PhD in herpetology. However, because of this, this expert has adequate knowledge to testify about the venom of snakes.
Your Honor, may I be heard?
Go ahead, please.
Your Honor, this witness does not have a degree in toxicology and cannot testify to evidence beyond her experience, and therefore she cannot testify to the neurotoxins in the snake.
Your Honor, may I respond?
Go ahead.
Again, this witness has a PhD in herpetology. This is the highest level of education one can reach in a given subject. This witness should know whether or not venom from a snake bite can cause cardiac arrest.
Okay, objections overruled. Can answer the question.
Yes, Your Honor.
Would you like me to re-ask the question?
Yes, please.
The neurotoxins in a Mojave rattlesnake's venom can cause cardiac arrest, correct?
I'm not sure about the effects on a human's body, as that is not my specialty, but after reading Dr. Dunn's statement, I do believe that is correct.
So, Dr. Clay, you do not know the exact effects of a Mojave rattlesnake's venom on a person, correct?
Yes, that's correct. It's not my specialty.
But Dr. Clay, you made conclusions based off of the Mojave rattlesnake's venom's effect on Eric Smith, this being that he died of pre-existing medical conditions, correct?
I believe that the venom of the snake did cause Eric Smith's death, but I believe that his pre-existing conditions exacerbated his conditions, which also led to his death.
But again, Dr. Clay, you do not know the effects of snake venom on a person.
Objection asked and answered. Your Honor,
Sustained.
this witness has already answered the question. Thank you.
Sustained.
Nothing further, Your Honor.
Okay, redirect?
Briefly, Your Honor, may I proceed?
Yes.
Doctor, how do you believe Eric Smith died in today's case?
Well, I agree with Dr. Dunn that the snake was the cause of the death, but I believe that the snake's venom also exacerbated his conditions, which also led to his death. But I do believe that the snake was the cause of his death.
And why do you
Objection,
believe?
Your Honor, this answer contains speculation. This witness has just testified to not knowing the effects of snake venom on a victim.
Your Honor, may be heard.
Go ahead.
Your Honor, in direct examination, opposing counsel asked this witness a similar question about how she believed Eric Smith died. And this is her professional opinion. As opposing counsel mentioned, she has a PhD in herpetology and can testify to how Eric Smith died in today's case.
May I respond, Your Honor?
Go ahead.
This victim does have, and this witness does have a PhD, as I stated, but has previously testified to not knowing the effects of venom on a human, and therefore cannot answer this question.
Objection sustained.
Yes, Your Honor. Now, Doctor, why is it highly possible for the snake to have sought shelter in the mailbox?
Well, during the day when the sun is out, snakes do prefer to be in a place where they can hide and get some rest so that later during the day they can hunt for prey. So I believe that the mailbox is one of the perfect places for them to seek shade and to get some rest.
Thank you, Doctor. Thank you, Your Honor. I have no further questions. May this witness please be excused?
Yes, absolutely. And the defense may call their next witness.
Yes, Your Honor. At this time, the defense calls Danny Emling to the stand.
Danny Emling, please turn on your camera and microphone. Danny Emling, please confirm that you can see and hear me.
I can see and hear you.
Please raise your right hand. Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
Please state your full name, spelling out your last for the record.
Danny Emling, E-M-L-I-N-G.
Your Honor, this witness's statement is located on pages 50 to 51 of the mock trial case packet.
You may examine the witness.
Yes, Your Honor. Good evening, Mr. Emling.
Good evening.
Could you please introduce yourself to the court?
My name is Danny Emling, and I own the best convenience store in all of Bernsley County, where I hear a lot of gossip.
Now, I'd like to ask you about two residents of Bernsley County, Mr. Emling. First, are you aware of a man named Eric Smith?
I am. He is, or was, my landlord.
And second, do you know a woman named Jamie Kobe?
Oh yeah, Jamie and I have known each other for a really long time now. We were both tenants of Eric and we're great companions.
Now, I'd like to direct your attention to the date April 28th, 2021. Where were you that day?
Well, I was at Jamie's mom's funeral. I mean, I had to be there for my friend.
And while at this funeral, did you observe anything of significance?
I did. I observed Eric and Jamie arguing again. Crazy how they couldn't even act civilized at a funeral. I wanted to stay and get all the good gossip, but I had to leave early.
Mr. Emling, you stated that you heard them arguing again. Have you seen them argue in the past?
Oh yeah, multiple times in fact. It's been going on for a really long time now.
Now, you've seen these arguments, Mr. Emling, but did you ever get to observe Miss Kobe's reaction to these arguments?
Well, from what I saw, and in my opinion, Jamie wouldn't typically act vengeful towards Eric. Maybe.
Objection, Your Honor, this is speculation.
Your Honor, if it may be heard.
Go ahead.
This witness does have the personal knowledge to be able to testify to this. As they previously stated, they've seen many of the arguments. And as they just stated that just now, they are testifying based on what they have seen. They do
Your Honor,
have
may I be
personal
heard?
knowledge to do this, as they are also great companions with Jamie Kobe and therefore can testify.
Ma'am,
Your Honor, may I be heard?
go ahead, please.
Your Honor, in this case, Danny Emling is testifying to something that he is speculating that the defendant heard, such as feeling or felt, such as feeling revengeful. Danny Emling is perfectly qualified to explain how he saw Miss Kobe react to certain fights, but he cannot speculate whether or not she was acting in a revengeful manner or not.
Your Honor, if I may be heard,
Go ahead.
this witness testified, they are testifying based on what they saw, and they are characterizing these acts as vengeful or not. And that is their opinion, Your Honor. They're not characterizing Miss Kobe's mental state. They do have the personal knowledge to be able to testify to this, and therefore this is not speculation.
Your Honor, may I be heard?
Go ahead.
Again, the exact words out of this witness's mouth were, they did not act in a revengeful manner, meaning that they are speculating as to the intent behind Jamie Kobe's acts as to whether or not they were vengeful or vengeful.
Your Honor.
If they want to pick a different word, they absolutely can, or speculate to what they saw. But in this case, the characterization makes it speculation.
Sustained. You may want to rephrase the question or ask something else.
Yes, Your Honor. Mr. Emling, what have you observed Miss Kobe do after arguments with Mr. Smith?
Well, typically from what I saw, and in my opinion, Jamie would cool down and apologize afterwards.
Thank you, Mr. Emling. Thank you, Your Honor. No further questions for this witness at this time.
Okay. Cross-examination?
Yes, Your Honor. May I proceed?
Yes, please.
Good evening, Mr. Emling.
Good evening.
You were a tenant of Eric Smith, isn't that right?
Yeah, I am a tenant of Eric. It was sad to see him go.
As well as neighbors with Eric Smith and the defendant?
Yeah, I was neighbors with both of them.
Now, you witnessed several fights between the defendant and Mr. Smith, right?
Oh yeah, I witnessed a lot of arguments between the two.
And as you just testified on direct examination, you saw that Miss Kobe calmed down, right?
I did see that, yes.
But Mr. Emling, the defendant would also come and vent to you after the fights, right?
Yeah, he would come and vent to me a few times.
And in fact, you knew that these fights angered the defendant, true?
Objection, Your Honor. Speculation, if I may be heard.
Sustained.
Motion to strike.
Granted.
Mr. Emling, you observed Miss Kobe getting angry after these fights, isn't that correct?
Your Honor, speculate. Objection, Your Honor, speculation.
Your Honor, may I be heard?
Yes, Your Honor.
Mr. Emling, would you like me to ask the question again?
Please do.
You observed Miss Kobe getting angry after these fights, isn't that right?
Yeah, I did observe her getting angry after these fights, but as I said, she would, typically from what I saw, she would calm down and apologize.
But you also know that the defendant would call the sheriff on Mr. Smith, isn't that right?
Yeah, I did see that a few times.
And you even witnessed the defendant putting animal waste on Mr. Smith's porch, isn't that correct?
I do recall that, yeah.
Now, Mr. Emling, you were friends with Jamie Kobe, isn't that right?
Yeah, we're very great companions.
And Jamie was a great person, in your opinion.
Yeah, she was a pretty good person, yeah.
And you did not like Eric Smith.
I have to be honest, I did not really like Eric.
In fact, you thought he was a terrible person.
I do recall saying that, yes.
Thank you, Your Honor. No further questions at this time.
Redirect, Your Honor.
Go ahead. Yes, you may.
Mr. Emling, opposing counsel asked you about your opinions of Jamie Kobe and Eric Smith. And would you let those opinions affect your testimony today?
No, I mean, I hear a lot of gossip, but I will only tell the truth here.
Thank you, Mr. Emling. Thank you, Your Honor. No further questions for this witness. May he please be excused?
Thank you very much. The witness is excused. You may call your next witness.
Yes, Your Honor. At this time, the defense calls Francis Yazzie to the stand.
Francis Yazzie, please turn on your camera and microphone. Francis Yazzie, please confirm that you can see and hear me.
I can.
Please raise your right hand. Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
Please state your full name, spelling out your last for the record.
Frances Yazzie, Yazzie.
Your Honor, this witness's statement is located on pages 45 to 46 of the mock trial case packet.
May I proceed, Your Honor?
Yes, you may.
Good evening, Ms. Yazzie.
Good evening.
Could you please introduce yourself to the court?
Yeah, of course. Hi, I'm Frances Yazzie, former owner of the Blue Agave, home to the world famous Maca Guac, and now I'm an artist who makes some of the best jewelry in California.
Now, Ms. Yazzie, you mentioned that you were the former owner of the Blue Agave. Could you tell us a bit about what happened?
Well, it's been super hard because of the pandemic to remain financially stable, and to be honest, your girl's broke. So, yeah, I had to close down my restaurant, and I'm not proud to say it, let go of all my employees, including Jamie Kobe.
Now, do you have a relationship with Miss Kobe outside of work?
Yes, Jamie's been my friend for oh my gosh, it's been 10 years now. She's super kind. That's why I like her so much. I feel like we've gotten much closer during our pandemic hangouts.
Now, Ms. Yazzie, I'd like to ask you about a resident of Berkeley County. Are you aware of a man named Eric Smith?
Yeah, actually, he was Jamie's landlord, and from what I saw, they didn't have the best relationship. I mean, they had a verbal argument, but to be fair, it was on the day of Jamie's mom's funeral.
Did you have the opportunity to speak with Miss Kobe after this argument?
I did, yeah. She came over around 4-ish after the funeral, and she still seemed a little worked up about what happened, but after an hour, by the time she left, she was just, in my opinion, usual Jamie, calm and even-tempered.
Thank you, Ms. Yazzie. Thank you, Your Honor. No further questions for this witness at this time.
Okay, the witness available for cross-examination.
Good evening, Miss Yazzie.
Good evening.
Now, the defendant usually gardened in early morning, isn't that right?
Yes, and
Objection, Your Honor. Lack of foundation, if I may be heard.
Your Honor, may I be heard?
Go ahead.
I believe you do not need foundation on cross-examination.
Your Honor, if I may be heard.
Go ahead.
I believe in cross-examination, foundation is also necessary if it hasn't been laid on direct examination. Furthermore, this witness hasn't testified anything about knowing about Ms. Kobe's gardening habits, and therefore, this is a lack of foundation.
Your Honor, may I be heard?
Go ahead.
I believe foundation does not need to be laid on cross-examination, and if foundation is needed, it has already been laid by the direct examination of Frances Yazzie. And therefore, Frances Yazzie will also know how the defendant usually went about their day, as they were best friends for 10 years.
Okay, objection overruled.
Yes, Your Honor.
Ms. Yazzie, would you like for me to repeat the question?
Yes, I would like that. Thank you.
Now, the defendant usually gardened in the early morning, isn't that right?
From what I know, correct, and sometimes in the afternoons.
And after they finished gardening, they would come to your house in the late afternoon?
Yes, around 4 p.m., if you could consider that late, yes.
And after the funeral, the defendant would come to your house, right?
Once again, yes, that is correct.
They came by at around 4 p.m.?
As I stated before, yes, they did.
The defendant seemed to be in an agitated state when they arrived.
Only on the day of her mother's funeral was she in an agitated state.
But the defendant mentioned how hurt they felt, right?
Yes, the day of her mother's funeral, she was really hurt. She had just laid her mother to rest. It was a very sensitive time for her.
But the defendant only stayed about an hour?
Yes, once again, it was a very sensitive time for her. She was very exhausted.
And they said that they were going to their garden around 5 p.m.?
Yes, they did.
You didn't see the defendant in their garden, right?
I was not there. I did not exit with her.
You didn't see her for the next days, did you?
No, I did not. But to be honest, I just wanted to give her a little space. Her mother had just passed away.
Thank you. No further questions.
Any redirect?
No redirect, Your Honor. May this witness please be excused?
Yes, yes, you may be excused.
Your Honor, may the defense call their last witness?
Yes, you may.
The defense calls Jamie Kobe to the stand.
Jamie Kobe, please turn on your camera and microphone. Jamie Kobe, please confirm that you can see and hear me.
I can see and hear you.
Please raise your right hand. Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
Please state your full name, spelling out your last for the record.
Jamie Kobe, Cobey.
Your Honor, this witness's statement is located on pages 40 to 44 of the mock trial case packet.
Okay. You may examine the witness.
Good evening, Miss Kobe.
Good evening.
Could you please introduce yourself to the court?
Yes. Hello. My name is Jamie Kobe.
Miss Kobe, can you tell us a little bit about yourself?
Sure. Let's see. I'm a member of a few animal rights organizations. I live alone, and I have to do part-time jobs in order to make a living. Let's just say the pandemic put a toll on my life.
Miss Kobe, what do you mean the pandemic put a toll on your life?
Well, you see, before the pandemic hit, I worked at the Blue Agave. I was able to pay rent, and I lived with my mom. But now I'm a part-time zero escapist, and my mom passed.
You mentioned that you lost your job. Can you talk a little bit about what that was like for you?
Of course. I gotta say, it was pretty rough. We mainly lived off my mom's disability check, so it was hard to pay rent. But I tried to, whenever I could. Let's just say when the eviction moratorium was provided, it was a relief.
Miss Kobe, you mentioned earlier that your mom passed away. I'm so sorry to hear that, and if you can you tell us how this happened?
Yes. My mom had pre-existing health conditions. She was on oxygen. And Eric Smith, he would turn off the electricity. One time when I was out gardening, the electricity was turned off and my mom's oxygen was cut. She went into cardiac arrest and died on the way to the hospital. But even after everything, I don't entirely blame Eric. I should have been there. And plus, she was ill. It was a matter of time.
Miss Kobe, did you have a relationship with Eric Smith?
I did, but it wasn't the best. We would often get into disagreements.
What do you mean by disagreements?
Well, you see, we would play petty pranks on each other, and sometimes the cops would be called. And regretfully, there was a time when we argued at my mom's funeral.
Can you talk about what happened at your mother's funeral?
Yes. I remember seeing Eric, and I hadn't invited him. I wanted him to leave. When I told him he should go, we began to argue, and Terry broke us up. After that, I knew I had to get out of there. I went to Francis's house to unwind, and then I went home.
Did you do anything significant when you got home?
Well, I did some gardening just to ease my mind. It normally works, but that day, snails and rabbits had ruined some of my favorite succulents. Poured my heart out into that garden. I remember getting so angry. I said that I was going to kill them, but I didn't mean it. I love animals. I wouldn't kill anything. I was just frustrated.
Now, Miss Kobe, I'm sorry to have to ask you this next question, but I do have to. Did you put the snake in Eric Smith's mailbox that bit and killed him?
No, of course not. And animal safety is one of my first priorities. I wouldn't do anything to harm them, let alone use an animal to hurt someone. I know Eric and we didn't get along. I mean, everyone knows that. But that doesn't mean I would resort to vengeance.
Thank you, Ms. Kobe. Thank you, Your Honor. No further questions at this time.
Okay, the witness is available for cross-examination.
May I proceed, Your Honor?
Please.
Good evening, Ms. Kobe.
Good evening.
Before we proceed, I just want to offer my condolences for your mother.
Thank you.
Now, Ms. Kobe, you went to Eric Smith's mailbox on April 29th, isn't that right?
Yes, I did. I was paying rent.
This was the day that Eric Smith got bitten?
Unfortunately, it was.
And you had a wire humane trap with you at the time, right?
I did, and some tools. It was around the time when I gardened.
And as you mentioned previously, you were dropping off your rent, right?
Yes.
As you just testified on direct examination, you paid your rent whenever you could, right?
Yeah, money was tight, but I tried.
And you did this as a sign of good faith, isn't that correct?
It was. I wanted Eric to know that I needed a place to stay.
But Ms. Kobe, after your mother's funeral, you were running out of money, isn't that right?
Sadly, I was.
You even sold tools that were essential to your business to pay for your mother's funeral, isn't that true?
I did. I wanted her to lay to rest quickly, and I had to make some sacrifices, so I sold my tools.
But even after trying to pay off your mother's funeral, you paid $48 for rent that week, isn't that right?
Yeah, money was really tight.
But Ms. Kobe, because of the rent moratorium, you didn't have to do that, isn't that correct?
No, but like I said, I wanted Eric to know that this was necessary.
Now, you didn't get along with Eric, isn't that right?
That's true. We didn't have the best relationship.
He threatened to evict you several times.
He did.
In fact, you called the cops on him, isn't that right?
Yes, and he's called the cops on me before as well.
At your funeral, you had a fight with Eric Smith, isn't that right?
We had an argument, yes.
And you said that you blamed him for the death of your mother, isn't that right?
I did, but just because I was overwhelmed with so many emotions. I didn't.
But later that evening, you yelled, "I'm going to kill them." Isn't that true?
Yes, the snails and rabbits.
And this was the day before Eric Smith died.
Yes, it was.
Thank you, Your Honor. No further questions at this time.
Okay, redirect,
Your Honor, may I proceed?
please do.
Ms. Kobe, opposing counsel asked you about the humane trap that you carried with you while you went to pay rent. Why did you have that with you?
Well, you see, it was around the time that I gardened, and I thought that I would just drop off the rent before I do so. Plus, you need tools when you garden. I mean, nature can be pretty dangerous. It's good to stay safe.
You were also asked about the tools that you use for your job and that you sold them. Why did you sell your tools?
Well, you see, I had to pay for my mom's funeral, and I wanted to do it quickly, just so she can lay to rest. So that's what I did. I sold my tools in order to pay for the funeral.
Lastly, Ms. Kobe, opposing counsel asked you about rent. Why did you pay rent even though your money was so tight?
I wanted Eric to know that I needed to stay there. I paid out of good faith. That's all.
Thank you, Ms. Kobe. Thank you, Your Honor. No further questions. May Ms. Kobe return to her seat at the end of virtual counsel table?
Yes, absolutely.
And Your Honor, with that, the defense rests.
Okay, so we've now heard the testimony of both sides, and now we're going to go to closing arguments. And so we're going to go first to the prosecution. If you're ready, you may proceed.
Thank you, Your Honor. I'm going to kill him. Your Honor, these are the words of the defendant. These words show the malice of forethought and the premeditation of Jamie Kobe and her intention to murder Eric Smith. After all, there is no better motive than avenging the death of a mother. Your Honor, simply put, this is a revenge killing. Tonight, the people have proved beyond a reasonable doubt that the defendant is guilty of the first-degree murder of Eric Smith. The defense has tried to paint tonight as an unfortunate tragedy, an accident of nature, if you will. That the snake coincidentally entered the mailbox on its own, already without a rattle, that Eric Smith only died because of his kidney problems, that the snake bite was unrelated. The defense will even try to tell you that the defendant was referring to some snails when she said, "I'm going to kill him." Your Honor, these alternative speculative theories are the defense's entire case, and they are just too coincidental. They do not raise reasonable doubt. The only reasonable conclusion in this case is that the defendant was upset, and she acted on that anger, just as she had done before. Your Honor, this wasn't an accident of nature. This was murder. Jamie Kobe was simply pushed too far, distraught and angry after the death of her mother. She put the snake in the mailbox and murdered Eric Smith. You heard from Deputy Garrett that when she interviewed the defendant, they were anxious to end the interview as quickly as possible. Not only that, but Deputy Garrett found anti-venom, multiple books on snakes, even rattlesnake rattles inside the defendant's home. The defense's excuse for owning these? She's a gardener. Deputy Sheriff Garrett, Danny Emling, Terry Edwards, and the defendant herself testified to the relationship between the defendant and Eric. It was volatile. She blamed Eric for killing her mother, getting into a fight at her mother's funeral. 2 days after, Eric was dead. Now, their relationship began with petty things, such as calling the police, leaving animal scat on property. But after her mother's death, Jamie was sick and tired of Eric and decided to take action. You heard Angel Russell tonight. He identified the defendant as the person who approached the mailbox with the cage that contains the snake. Now, mail was found from April 30th. Rent checks from every other tenant were found. The defendant's wasn't. She couldn't even afford to pay rent that month. She only paid rent when she could, and simply put, that month, she could not afford it. The defendant testified to wanting to pay off her mother's funeral as fast as possible, to lay her to rest. So why waste $48 on a rent you didn't have to pay? Why was she at the mailbox? Your Honor, she was there to place a snake with the intent to kill Eric Smith. The defendant had every opportunity to commit this crime. She waited till dawn when she knew that snakes were more active. She retrieved a Mojave rattlesnake. She removed its rattle. She put the snake in a cage and walked over to Eric Smith's house. She opened up the mailbox. She placed the snake inside, and she murdered Eric Smith. This was not some freak accident of nature. This was intentful. Now, Your Honor, to charge someone with first-degree murder, the people have to prove 3 elements: that the defendant's action led to the death of the victim, that the defendant intended to kill, and that the defendant willfully and with premeditation murdered Eric Smith. The first, that the defendant's actions led to the death of the victim. Your Honor, you heard from the medical expert, Dr. Charlie Dunn, tonight, the only expert present that actually examined Mr. Smith's body. She concluded that the snake venom killed Eric Smith. The second element of first-degree murder is that the defendant intended to kill. The evidence of that intent? Her own words. "I am going to kill him." 2 days later, he was dead, after Jamie had placed the most venomous snake in North America in his mailbox. This is not nature, Your Honor. The third element that the people had to prove is that the killing was willful, deliberate, and premeditated. The defendant had the means and the knowledge to commit this murder. Your Honor, she knew that the Mojave rattlesnake was deadly. She knew that removing the rattlesnake would remove any chance of Smith getting a warning. And she knew that Eric Smith would not survive. She even risked her own safety to make sure that Eric Smith would die and that it would look like an accident. The third element has been proven. Now, even if Your Honor does not believe that the defendant had malice aforethought when committing this murder, the people have also charged the defendant with a lesser charge of voluntary manslaughter, only consisting of 2 elements: that Jamie Kobe took a life, which has been proven, and that this was a murder in the heat of passion. Your Honor, there has been several moments throughout this trial where we have seen just under how much duress Jamie Kobe was. Today, the people have shown that the defendant's actions resulted in Mr. Smith's death, that the defendant intended to kill, that the defendant willfully and with premeditation murdered Eric Smith. Therefore, the people, Your Honor, may I finish my sentence?
Go.
Therefore, the people have proven beyond a reasonable doubt all 3 elements of first-degree murder. Thus, the prosecution asks that you find the defendant, Jamie Kobe, guilty. Thank you.
Great. Closing from the defense.
Yes, Your Honor. May I proceed?
Please do.
It's April 29th, 2021. It's sunny outside and there's a snake. Scrambling to get away from the sun, it looked and looked until it finally found its salvation. A mailbox. It squeezes through the top slot and is finally relaxed. But a little while later, it's startled. Someone is reaching into the mailbox. Just trying to protect itself, it reaches out and bites the wrist. The wrist of Eric Smith. Your Honor, in today's case, revenge didn't kill Eric Smith, nature did. The people have charged Jamie Kobe with first-degree murder and voluntary manslaughter. In bringing these charges, they brought upon themselves the highest burden in our legal system. A burden to prove every element of every charge beyond a reasonable doubt. But let's take a look at the evidence you heard today. Dr. Tyler Clay, an expert in herpetology, found that it's extremely likely that the snake crawled into the mailbox on its own accord. In fact, she has seen cases where snakes climb into mailboxes. The bite occurred during the window of time where Mojave rattlesnakes are the most active during the year. This, coupled with the fact that the snake simply wanted to find a dark and closed space, makes it more than probable the snake simply wanted to seek its own shelter. But today, the people have twisted this story. They want you to believe that Miss Kobe placed that snake into the mailbox. But let's take a step back and remember the testimony of prosecution witness Angel Russell. I never saw Miss Kobe wearing gloves. The only eyewitness in today's case never saw Miss Kobe wearing gloves. And as Dr. Clay mentioned today, bite-resistant gloves are the only way to ensure safety when handling a snake. And Miss Kobe, an expert gardener, would reasonably know this. So if she was handling a deadly snake, Your Honor, why wasn't she wearing bite-resistant gloves? Because she was there to pay her rent. And while she was there, Mr. Russell was the only person watching. And the only person watching never saw a snake in the cage Miss Kobe was holding and never saw a snake being put into the mailbox. The only time Mr. Russell saw a snake was when it bit Eric Smith. The prosecution has failed to provide a witness that can testify to seeing Miss Kobe put a snake into Eric Smith's mailbox. But today they brought Deputy Sheriff Tony Garrett, a deputy who only searched one place in Miss Kobe's house, the living room, and she glanced at the garage. She didn't check a bedroom. She didn't check a dining room. Your Honor, she didn't even search the entire house. She didn't search the entire house of the person she later arrested, Miss Kobe. And then she took the stand herself and told you what really happened. On April 28th, Miss Kobe attended her mother's funeral. And all she wanted to do was mourn the death of her mother. And then Eric Smith shows up uninvited. Yes, they argued, but Your Honor, as you heard from Miss Colby's close friend, Frances Yazzie, that after this argument, Miss Colby cooled down, as she usually did. Both the people and the defense agree that Mr. Smith and Miss Colby argued a lot. But Your Honor, despite what the people may think, that is not an excuse for murder. Today, Terry Edwards took the stand and told you he heard Miss Colby say, "I'm going to kill him." But Mr. Edwards also told you that he wasn't directly next to Miss Colby, nor was Miss Colby speaking directly to him. He also told you on stand today that he didn't view the statement as important. And then Miss Colby took the stand and told you what she really said. Miss Colby said 6 words. "I'm going to kill them, not him, like the people want you to believe." Your Honor, if you can draw 2 or more reasonable conclusions where one points to innocence and the other to guilt, you must accept the one that points to innocence. Today, the people have presented numerous pieces of evidence throughout the trial. But all this evidence has one thing in common. It's circumstantial. Not a single prosecution witness could tell you today that they saw Miss Colby with a snake. Not a single person could tell you that Miss Colby put this snake into the mailbox. And Your Honor, standing here at the end of this trial, one thing is clear. The people simply have not met their burden to prove every element of every charge beyond a reasonable doubt. There was no motive, no murder. Because in today's case, revenge and kill Eric Smith, nature did. Find the defendant not guilty. Thank you.
Okay. Now we're gonna have rebuttal from the people.
Yes, Your Honor. May I proceed?
Please do.
Your Honor, nature did not kill Eric Smith. Jamie Colby did. Now, Ms. Rocha just said that the snake bit at the most active time of the year, which she's right about. Spring is a very active time for snakes. But Miss Colby was bitten at the least active time of day. At that time of the day, snakes just want to relax in some shade. They don't want to climb up a mailbox, Your Honor. Snakes are more active at dawn, something that Jamie Colby knew. Ms. Rocha also pointed out that Deputy Sheriff Garrett didn't search the entire house. And yet, in the portion of the house that she did search, she found anti-venom, rattlesnake rattles, protective gear, in that short search alone. Deputy Garrett has been the sheriff of this town for years, and she believes that she conducted a rightful investigation. Your Honor, Danny Emling testified tonight that Jamie Colby always calmed down. But then they went on to testify to several responses that Jamie Colby had, putting animal scat on someone's porch, yelling, calling at the cops. Your Honor, we ask you to find Jamie Colby guilty.
Okay, and now rebuttal from the defense.
Yes, Your Honor. May I proceed?
Yes, you may.
Revenge and kill Eric Smith, nature did. Your Honor, you heard on stand today from expert witness Dr. Clay that it's extremely likely for the snake to have entered the mailbox on its own accord. In fact, she has seen other cases where snakes have climbed into mailboxes, and that alone, Your Honor, is reasonable doubt. But the people have twisted this story. Miss Forrestal told you that the snake was put into the mailbox by Miss Colby. But you heard from their own witness that they never saw Miss Colby with a snake, never saw Miss Colby putting a snake into the mailbox. Today, the people have failed to provide a witness that can testify to seeing Miss Colby with a snake. And today, the people have not met their burden. Because in today's case, revenge didn't kill Eric Smith, nature did. There was no motive, no murder. Find the defendant not guilty.
Okay, we've now heard all the evidence, all the arguments been made, and at this point, I'm going to be in a moment announcing my verdict, which has no bearing whatsoever on who wins the competition. but I believe that this is a point where the team should be able to, first of all, consult with each other, with their teams, to see if there are any irregularities that you want to bring to our attention before the scoring is done. And while everyone's doing that, I do want to take one moment of personal privilege here to just say one thing to everybody, which I mentioned before whenever I've judged this particular fact pattern, which is, as I mentioned at the beginning, I hear the unlawful detainer, the eviction calendars. If you are a landlord, do not turn off people's power as a self-help measure. That is illegal, it is bad, and it can lead to terrible things happening, like people dying, which is, so that's my public service message sort of for the evening while you consult with each other. And so do not ever resort to self-help as a landlord. Also, as a tenant, don't kill your landlord if they do, but that's another thing entirely. That's not saying how I'm ruling.
Your Honor, the people have no trial irregularities.
Okay.
Your Honor, the defense has no trial irregularities either.
Okay. I have to say that I'm not at all surprised by the outstanding quality of what I've heard today, given that this is the final. And I've seen, I think, a bunch of these folks before. And so I know that in previous years as well. And so I know that you're a great experienced group. But when it comes to the verdict on this, I'm really surprised. With regard to the idea that this, let me just pull this up. With regard to the count of voluntary manslaughter, I don't think that this is a heat of passion situation, because what's alleged here is just far too involved in terms of a setup for it to be just a passion. That requires malice, forethought. It requires actions be taken in advance if indeed this was a murder. And wow, you convinced me that it was. I find the defendant guilty. I'm really shocked. But anyway, but that's just my verdict. And trust me, having me find somebody guilty, honestly, I just can't imagine why in the world she would pay, when she had no money, why she would go and pay the rent to the person who just, they thought murdered their mother. And I think I kind of agree. And so revenge sounds reasonable here. And so, and I think that's, I don't see a way, it just makes no sense to me, the defendant's arguments. But anyway, not that the defense didn't do a great job, just that for some reason or other, I'm actually convinced this time. And so, but I'm not the one that makes the decision here. It's all based upon the scoring.
The people would like to award our award to Karina Rothrow. We thought your closing was fantastic, and that you did an amazing job throughout the duration of the trial. Fantastic job. We love competing against you guys. You're a fantastic competitor. It was a great time, and you did a fantastic job.
Thank you. The defense wants to give our award to the pretrialer, Sydney. We thought you did a fabulous job starting the trial off.
Oh, cool. Absolutely great. And everybody was really outstanding. And I'm sorry, there were a couple of times where some of the witnesses were just so into it that I did chuckle, and I'm sorry about that, because I'm trying to be serious here. But it's like, wow, you guys really got into it.
And again, in a competition like this, at this stage of the competition, we have two of the strongest teams, obviously. And so what happened is what we would expect. It was a very, very close match. We have two very evenly matched teams, very experienced teams with a great history of excellence in mock trial. And so we saw that tonight again, and I just want to appreciate that from both sides. The bottom line is that based on the conclusion of our 5 scorers And I want you to know that we had 5, which was an effort to ensure a fair outcome and an accurate outcome, though the score was very, very close. And I will be able to offer and share the final results with your coaches, who I'm sure will extend them to you. I can say now that the team playing the defense this evening, which I can say now publicly is Moreau Catholic, did in fact earn more points overall from the scorers and will in fact be awarded the county championship. So big congratulations to Moreau for a victory this evening in a very closely fought match. And big congratulations as well to the other team, in this case, Bishop O'Dowd, which put on a remarkable performance this season, making it to the final and putting up an incredible performance this evening. So with that, I can officially say that we will be sending our team to the state championships, and that will be Moreau Catholic defending Alameda County and hopefully performing well. And we want to wish you the best of possible luck. And I think in that spirit, I would like to suggest, Judge, if you're okay with it, that we would provide a chance for both yourself and the scorers to give a little bit of feedback. I know it's kind of a late night and we've had a bit of a rough ride this evening, and that don't want to keep people too late, but I think it would be appropriate for the scorers to give a little bit of feedback and their impressions of the trial this evening.
I would like to hear, I think that would really be helpful is to hear from the people who were scoring rather than from me, because, you know, all I'm going to say is that you guys were all amazing. And I have my own ideas I have my own MVP, but I'll tell them separately maybe later. But I'd like to hear what the scorers have to say.
So I think I've seen both teams throughout the competition. My name is Mike Lodge. I'm an attorney for Chevron, and more importantly to this moot court competition. I'm a former JAG in the Coast Guard, prosecutor, judge, and appellate court judge. All I have to say is, wow. I have never been involved in the finals before, and it was just an incredible performance by both teams. It was just incredible. I don't know any other way of saying it. I mean, there was, I've got some general comments that I'll get to both teams, but very clear active listening by the counsel. Very, very good cross-examination and, you know, getting to not just what was in the script, but getting to the points that obviously were made. And in particular, a very judicious use of objections tonight, which I think the judge probably appreciated, and I certainly appreciated listening to the mock court. But the back and forth between counsel as a result of objections was better than probably most trial attorneys their first or second year out of law school. It was just phenomenal to watch, and again showed not just a mastery of the facts of the case, which I would expect at this point in the competition, but also a mastery of your advocacy skills, which you know, I just hope that many of you who performed tonight think about going into the legal profession upon graduation from high school and hopefully university. I just have I have a lot of comments written, but I wanted to keep it really general for the team. But I just want to call out one extra person that usually doesn't get called out, and that is I think he's considered the bailiff on the defense team, who was swearing the witnesses in. Best job I've ever seen of a bailiff, and I just want to make sure that he heard directly from me that I thought it was a fantastic performance. Back to you, Judge.
I was gonna say that's the best I've actually seen probably in 12 years of that. I was really not just real command of it. And so I also want you to know that towards the end, I was I was not allowing as much give and take going on, because I was really getting worried that you guys were getting so wrapped up in that you were going to burn all your time, you know, just getting into the give and take there. But anybody, we have other scorers here, and I'd love to hear from you guys.
I guess I can say something. Hi, everybody. My name is Jennifer Martin. I am an estate planning and estate litigation attorney in Pleasanton. I think I've seen both teams as well. You may remember I do litigation, but it's civil litigation, so I don't go in a criminal court like you were simulating tonight. And as you probably also know, if you've seen me before, my connection to this competition is I'm actually an alumna of this competition. When I was your age, I competed for Amador in this Alameda County mock trial competition. And I will say the quality of both teams tonight, I agree. It was probably the best I've ever seen. And I have seen at least one other final, but very high quality. I just have two specific comments. The first is I thought there was a really good job specifically in opening arguments, specifically for the defense. I've never seen someone incorporate the opposing side's theme in their opening arguments, and the defense did that tonight, and I thought that was absolutely wonderful. It's a unique privilege for the defense, of course, because the prosecution doesn't get to hear the defense's opening argument first, but I think if you can do it and you're on the defense side, I think it's very clever. It's repurposing their theme for your purpose, and I thought it worked really well. I will also say there were some incredible performances specifically by the experts on both sides tonight. I thought they were very clear about the technical evidence. I thought the attorneys working with them helped walk them through on direct examination in a very clear fashion, the technical elements of the case that they're speaking to. And I thought they both spoke really authoritatively, and they sounded like real experts to me, which I think is quite a feat. So very good job. And then finally, I'll just commend, and I know the defense team had me score earlier this week. I still maintain that I think it's very important to consider how would my witness behave at a murder trial, which I think is a little bit different than how they would behave in real life. But on the other hand, you clearly got the higher scores tonight, so other scorers may feel differently about those performances. But I thought overall, especially the defendant, Ms. Kobe, that was an excellent representation of how someone would truly behave in a murder trial when they were the defendant, and Dr. Clay as well, how an expert witness at a murder trial would truly behave. So very good job. Thanks, everybody.
I can go next. I have a shout out for the prosecution closing argument. I'm not surprised the way that the judge ruled tonight. And in my experience of having done a lot of this season, usually the defense wins. And in this case, it was the prosecution that won. And I think it was a very excellent closing argument. Everybody clearly knows the case. They know their roles. Everybody did a great job. I hope a lot of you, if not all of you, decide to go to law school because you have a gift that I see. The only thing I'd say for the team that's moving on is that there might be a few times where a little bit more inflection, like a little more brightness in your speech. It's not that you're reading, you know the case, you know your arguments, you know your objections, but maybe a little bit more lively, because a trial is like theater. I say that almost every time, but it really is. And you need to convince somebody, and you know the facts and the case so well, but be excited every time you speak. Let's see. Oh, I guess I would say also, I concur with the judge. My specialty is in real estate. Don't ever turn off the utilities. This should have ended up in civil court, not in criminal court. Thank you. Good luck, everybody.
I'll go next. Good evening, everybody. My name's Tina Heimer. I'm also an attorney at Chevron as well. And I'm not going to take too much time because I think a lot of my comments are very consistent with the other scorers today. So I just want to wish you all luck. I think both teams did a great job. I've done a couple of these. I have not seen either of the teams that are at the finals tonight. And so this was just a really impressive command of the case and performance by both teams. And I truly think that this case was fought on the cross-examinations on both sides. I think that's where a lot of the piercing information came out. You know, I don't think actually in the previous cases that I've scored before, anybody's actually even questioned whether there was a snake in the cage or whether they saw whether Angel Russell saw the snake get from the cage to the mailbox, and which I think is really kind of important fact in this case. And then also too, I think, you know, both sides just did a great job of incorporating each other's facts in there. So I wish you all the best of luck moving on, and I'm going to be following you all. So good luck. Take care.
Was that all? Do we have another scorer to speak? Oh, yes.
Hi. The last scorer I think to speak tonight, and I think I have judged or scored both of the teams. I reiterate everything that everybody has said before. To throw a couple more comments in, I think a lot of the witnesses are the unsung heroes, and both teams had some really great witnesses that got you a couple extra points here and there because they knew their stuff. They didn't come off snarky. They responded well. They advanced the theme of whatever team that they were on, so they did a really good job. So I can't emphasize enough that even though you feel like you're the witness and you don't get to do the fun stuff so much, that's still a really vital role, and it still, you know, advances the team and advances the story. And I think everybody who had their witnesses testify tonight were fantastic. It shows that you're ready to do this and you know what you're doing and you've got it together. And like one of the other scorers said, this isn't an easy thing to do. Most, if not every single person in here is better than the majority of attorneys that I see in case on a regular basis. So you really should commend yourself. It's a skill and it's a talent that a lot of people will never have. And every single one of you tonight has a great talent.
You know, I agree with that entirely. One thing I do want to say is that we all say, you know, you really should think about going into becoming lawyers. And I think that there's a lot to be said for that. But I also want to point out that the skills that you develop doing this, the ability to present your position to other people, the ability to think on your feet, the ability to speak and in a rational way and in a way that's persuasive can be valuable to you if in in many different types of professional environments. Engineers, doctors, you know, architects, business people, the scientists. There'll be a time when whatever your path is, where you may have to get up in front of a bunch of people and persuade them of something. And I really think that the skills that you develop doing this will help you. However, although some of you really would make really good lawyers, and so, but you should all be very, very proud of yourselves. And the only thing that saddens me is it looks like I probably should have done the shout out earlier, because I really wanted to say that that closing from Ms. Forrestal really blew me away. There you are. That really blew me away. And that's what changed it for me. It was your closing. And so, but it was really just amazing on everybody's part. You guys were all so good. Thank you for allowing me to be here to judge this, and good luck to all of you. And I think some of you we may see later in the year at various events.
Right. Speaking of which, we are going to have an awards ceremony And I would just really extend a hearty invitation to everybody to come to that, including our scorers and judges. I'll send the formal invitation out for that event. And I'll probably speak a little bit more at that event. So I'm going to keep my final comments very brief here. But I do want to underscore a point that the judge made just now, and my colleagues from ACOE, if Dawn is still with us, I'm sure would concur that her being a scientist and a leading educator in the field of science, your ability to think analytically is just so vital. And as a person who did not work in the legal profession, but has been in education for many years and has seen a lot of situations in professional settings where people in some cases lacked those abilities, and in other cases they had them as a pronounced skill. It is clearly evident when you're in the workplace what's going on with people's skills, and the ones that I think why I'm become such a big fan of mock trial is exactly that reason, that you're developing the skills that can apply to any field professionally. And another topic that I feel very strongly about, which is what it means to be a citizen. We live in an unusual time, as you guys know. There is a lot of information that's out there. Some of that information is probably accurate. A lot of it, not so much. So your ability to be able to parse through, we'll just call it evidence, because ultimately you're going to be voting, you're going to be making decisions about the common good. And it's just thrilling for me to know that you people are going to be able to see through what may be considered misinformation because of your ability to, almost like an attorney or like a witness, be able to parse through that information. Supposed evidence is invaluable and more important today than ever. So can't appreciate enough the value that I hope you all feel like you're deriving from this experience. Again, just hearty congratulations to both teams. To make it to the finals, you know what you had to go through to get here. So please don't for a moment consider that you didn't do an amazing job to get here as individuals and as a team. And that's the other thing that's so striking about this competition. It's individual, but it's also a team. And you had to pull together and support each other. And I can only imagine what your rehearsals are like. It would be fun to be a fly on the wall and to watch that. I also need to, speaking of which, a special shout out to your coaches, who I know you probably appreciate on a regular basis. But I just want to say on behalf of the Alameda County Office of Education, thank you for your incredible commitment to your students and to the teams. Some of you have been at this for a long time, and it's just astounding how much commitment you have to your teams and to the legacy of your program. So thank you for that. And again, thank you to the scorers. I know all the participants understand how much time you've given as pure volunteer time, but I just hope you will appreciate that one more time with me and thank the scorers for their time, some of whom have been doing this for a long time, for many years, and did a lot of competition tonight. I do want to note that it is my goal to always make sure, as to the degree possible, that people have only seen a team a single time. But because people have scored so many matches, at a certain point, we know they're going to have seen other teams. So I hope that you can understand that that's just the reality of the competition. And I also hope that you'll trust there's no bias built into that. These are highly professional, high integrity people who are going to obviously judge you based on the merits of what you present. So I just want to underscore that point. But with that, Judge, I think unless anybody else has any comments for the good of the order, I think we're pretty much done. Any final comments that anybody wants to share?
I do want to say one last thing before I go, which is that I called out one person. I do want to say that Ms. Ratra, I understand why you were recognized by the other team, because you were outstanding as well. The closings on this were superb. The openings and closing statements were superb in this case. Absolutely. I understand why everybody was so excited, but I called out one person. I wanted to say that end, I was whipsawed. Really great job. Thank you all.
Thank you.
All right, any final words for the good of the order? Anybody have a closing thought? Otherwise, I think we can let these tired young people go.
Thank you, Ben. Thank you, everyone.
Even some of us tired old people.
Thank you, Your Honor.
Thank
you.
Thank
And
you very
much.
Thank you.
Bro.
what time it is in New York?
Oh my God, yeah.
Bed.